I just heard him on the other side say, "Dad has been
Yeah, she was heavy.
What did y'all do?
They put her in the tub.
Home invaded, kidnapped, hijacked.
Nioki Bull, age 23, has received a sentence of 20 to 70 years in the Department of Corrections. Bull pled guilty to second-degree homicide in connection with the death of Marcus Olmstead. In December 2018, Bull went to Olmstead's residence and fatally shot him with a crossbow bolt. After spending 32 months navigating the court system, Bull agreed to plead guilty to the lesser charge of second-degree homicide. This decision was made after discussions with the Olmstead family, confirming a conviction and offering them an opportunity to begin the healing. At the sentencing hearing, Marcus Olmstead's father, Robert Olmsted, shared an emotional account of the night his son died, highlighting the lasting effect of the tragedy on their family. Nioki Bull also spoke to the court, offering an apology to the Olmsted family and expressing his regret for his actions. Muskegon County Circuit Judge Annette Smedley handed down a sentence of 20 to 70 years, allowing for Bull's potential parole at the age of 40. Nioki Bull's sentence includes a credit of 973 days for the time already served in the Muskegon County Jail. His guilty plea and the serious nature of his crime resulted in a lengthy prison term for taking the life of Marcus Olmsted, a young man whose future held great promise. In Bakersfield, California, 27-year-old Tobias Roman, also known as Giggles, faced multiple charges at his arraignment, including attempted robbery, making terroristic threats, and wielding a deadly weapon. The charges came from allegations that he stalked a female mall employee, leading to his arrest. During the hearing, a tense moment unfolded when Roman initially refused the bailiff's order to stand. However, after Judge Charles Bamer firmly instructed him to do so, Roman complied, setting a contentious atmosphere for the proceedings. Once Roman stood, Judge Charles Bamer moved forward with routine procedural questions, beginning with a confirmation of Roman's legal name. Although Giggles was his street alias, the seriousness of the charges before him stripped away any humor from the situation. Judge Bamer then appointed a public defender to represent Roman. As the judge outlined the primary charge of attempted robbery, Roman attempted to interrupt, leading Judge Bamer to firmly instruct him to remain silent, asserting his authority to maintain order in the courtroom. After repeated interruptions and a call for silence, Judge Charles Bamer issued a stern final warning to the defendant. He made it clear that this was the last chance for Roman to conduct himself appropriately in the courtroom. The judge cautioned that any further failure to comply would lead to Roman being removed from the proceedings. He framed this as a choice for Roman, emphasizing the seriousness of the situation and the importance of maintaining decorum. Initially, it appeared that Giggles might comply and quiet down, offering a brief moment of calm. However, this pause was short-lived as he continued to speak out of turn. In response, Judge Charles Bamer ordered Giggles to be removed from the courtroom. As deputies escorted him out, Giggles muttered an alarming threat under his breath, stating that he would murder the judge the next time he saw him. Aware of the severe implications of the statement, Judge Charles Bamer immediately took action. He addressed the court, requesting that Giggles' menacing remarks be officially recorded. He recounted how Giggles had openly declared his intention to commit murder if their paths crossed again. Judge Bamer stressed the necessity for law enforcement to respond decisively to this serious threat, underscoring the importance of ensuring the safety and security of everyone involved in the proceedings. Subsequently, Giggles entered a plea of no contest to the charge of threatening a public official, which resulted in an 8-month prison sentence. Remarkably, all other charges against him were dismissed except for the offense of threatening with intent to terrorize. Giggles also pleaded no contest to this remaining charge, leading to a separate 3-year prison sentence. These legal outcomes mark the culmination of the judicial process, holding him accountable for his actions. Zion Talavera, a 22-year-old from San Antonio, was implicated in a series of aggravated robberies in 2019. During one of these incidents, he and an accomplice seriously injured 58-year-old store owner Gemunu Gamarachilaj. After battling for his life in the hospital for over 500 days, Gamarachilaj tragically passed away due to his injuries. The repercussions of this violent act were profound, leading to devastating losses for his common-law wife, Linda Lopez. In court, Lopez spoke about the tremendous impact the incident had on their lives, highlighting the emotional and financial toll it took.
I just heard him on the other side say Dad has been shot and he's in the hospital.
At the time of the crimes in 2019, Zion Talavera was 18 years old. Following the death of Jemunu Gamarachilaj, Talavera faced capital homicide charges. However, through a plea deal, he was sentenced to 50 years in prison on a reduced charge of homicide. Prior to this, he had already been sentenced to 20 years for aggravated robbery. Both sentences will be served concurrently. In addition to his prison term, Talavera has been ordered to pay over $2 million in restitution. Zion Talavera is required to serve at least half of his 50-year sentence before he becomes eligible for parole. His co-defendant, Armando Narvaez, also entered a plea deal and was scheduled for sentencing on October 13th. The acceptance of these plea deals concluded the case without a trial, which spared the victim's family the emotional burden of a prolonged court process. Today, at the Rockdale County Superior Court, we look at the shocking case of identical twins sentenced to 30 years in prison for stabbing their mother and leaving her to die in the bathtub. Jasmia and Tasmia Whitehead, only 16 at the time, committed this brutal act, even severing their mother's spinal cord. The motive for this shocking crime is still unknown, but the evidence against the twins was overwhelming. They were arrested and charged with malice murder, felony murder, and aggravated assault. In the quiet town of Conyers, Georgia, this horrific crime shocked the community and captured national attention. The brutal act by 16-year-old identical twins, Jasmia and Tasmia Whitehead, against their mother, Jarmeka Whitehead, left everyone questioning how such darkness could exist within two young girls. Jarmeka, a 34-year-old woman, should have been a source of love and protection for her daughters, but instead became their victim. Tension and turmoil marked the events leading up to that fateful day. Friends and neighbors later recalled the strained relationship between Jarmeka and her twin daughters, which was filled with arguments and resentment. However, no one could have predicted the horrifying events that would unfold. It began with an argument in the kitchen after the twins woke up late for school. They claimed their mother threatened them with a pot from the stove. The twins said they wrestled the pot away from her, which then escalated into a full-blown brawl.
Mom's yelling?
We all yelling.
Everybody's yelling.
We all we mad.
We were all yelling and mad. Somehow she got a knife. I don't even remember a knife block, but she had a knife, said Jasmia. I took the pot from her, then she grabbed the knife and told us to get back, but she didn't keep the knife in her hand, added Tasmia.
You had her by the hands,
Yeah, I think I had it. I was at the top.
and Jazz had her feet.
Yeah, she was heavy.
What did y'all do?
They put her in the tub.
The aftermath of the crime was filled with shock and disbelief. Police arrived at the scene and began their investigation. The evidence against Jasmia and Tasmia was overwhelming, with their DNA found at the crime scene and witnesses testifying about their troubled relationship with their mother. The trial became a media sensation, attracting reporters from across the country eager to uncover the shocking details of the case.
Good afternoon, Judge. Good afternoon. We are here in the matter of the state of Georgia versus Tasmia Janisha Whitehead.
The prosecution portrayed the twins as consumed by anger and resentment, willing to do anything for revenge. The defense argued that underlying issues drove the twins to commit this unthinkable act. As we continue to undo the shocking case of Jasmia and Tasmia Whitehead, the identical twins who brutally stabbed their mother, Jarmeka, and left her to die in the bathtub, we explore the motives behind this unthinkable crime. Friends and acquaintances of the Whitehead family were left confused by the tragic events of that day. They described Jarmeka as a loving and devoted mother who always tried to provide for her daughters. However, beneath the surface, hidden tensions and simmering resentments eventually erupted into violence. During the trial, it was revealed that Jasmia and Tasmia had a riotous upbringing. Their parents divorced when they were young, and their mother primarily raised them. Despite Jarmeka's efforts, the family struggled financially, and the girls were exposed to a turbulent environment. As the twins entered their teenage years, the strain in their relationship with their mother became increasingly evident. Arguments and disagreements became regular, and the once close bond between mother and daughter unraveled. The twins felt neglected and misunderstood. harboring deep resentment towards their mother. Tensions reached a boiling point in the months leading up to the crime. Arguments escalated, and the girls grew frustrated and angry towards their mother. It was within this toxic environment that the seeds of their unthinkable plan were sown. The twins began to confide in each other, sharing their darkest thoughts and fantasies. They found solace in their shared resentment towards their mother, fueling each other's anger and pushing each other further into darkness. On that fateful day, Jasmiyah and Tasmiyah fell into a chaotic argument with their mother, releasing all their pent-up frustration. With a coldness beyond their years, they launched a vicious attack on Jarmeka, inflicting wounds so severe that they severed her spinal cord. During the trial, the defense argued that the twins were victims themselves, trapped in a cycle of abuse and neglect. They claimed the girls acted out of desperation, seeking an escape from their troubled lives. However, the prosecution painted a different picture, emphasizing the calculated nature of the crime and the lack of remorse shown by the twins. Ultimately, the jury sided with the prosecution, finding Jasmiyah and Tasmiyah guilty of first-degree murder. In delivering the sentence, the judge acknowledged the tragic circumstances but emphasized the severity of the crime. The twins were sentenced to 30 years to life in prison, ensuring they faced the consequences of their actions. The impact of this shocking crime reverberated throughout the community. Friends and neighbors were left struggling with the unimaginable, struggling to imagine the innocent girls they had known as cold-blooded killers. The tragedy of Jarmeka's death and the betrayal by her own daughters would forever haunt those who knew her. The verdict sent shockwaves through Conyers, Georgia, and beyond. Friends, neighbors, and even strangers following the case closely were left reeling from the crime's unimaginable nature and the punishment's severity. The community was divided. Some sympathized with the twins' troubled upbringing, while others demanded justice for Jarmeka. In the days following the trial, media outlets across the country descended upon Conyers, eager to capture the reactions of those closest to the case. Reporters sought interviews with friends, family members, and former classmates of Jasmiyah and Tasmiyah, hoping to shed light on the events that led to this shocking crime. Jarmeka's memory lived on in the hearts of those who knew her, and her tragic death served as a constant reminder of the fragility of life. For Jasmiyah and Tasmiyah, life behind bars became their new reality. The once inseparable twins, who had shared an unbreakable bond, were now separated by prison walls. Their lives were forever changed, and they were forced to confront the consequences of their actions. In prison, the twins faced a new set of challenges. Their youth and the nature of their crime made them targets for other inmates, forcing them to adapt quickly to their new environment. While imprisoned, Jasmiyah and Tasmiyah had time to reflect on their actions and the pain they had caused. They underwent counseling and therapy, attempting to understand the root causes of their violent behavior. It was a journey of self-discovery and redemption as they struggled with the weight of their past and sought to rebuild their lives. This is Gary Gilmore, a notorious criminal facing murder charges in Utah. In 1976, he committed 2 brutal and senseless murders. Gilmore demanded to be executed and chose the method of his execution, refusing to appeal his death sentence. Many saw this as just punishment for his crimes. On July 19, 1976, Gary Gilmore robbed and murdered Max Jensen, a gas station attendant in Bravo, Utah. 2 days later, he killed Benny Bushnell, a motel manager in Salt Lake City. Gilmore was arrested shortly after the second murder and quickly confessed to both crimes. During his trial, his defense argued that he was mentally unstable and should not be sentenced to death. However, Gilmore refused to cooperate with his lawyers, repeatedly demanding execution. He even fired his lawyers and announced he would represent himself during the sentencing hearing. Despite his lawyers' protests and his family's objections, Gilmore's wish for execution was granted. He was sentenced to death and sent to Utah State Prison to await execution. While on death row, Gilmore gave media interviews and gained notoriety. His story inspired several books and a made-for-TV movie. On January 17, 1977, he was executed by firing squad, marking the first U.S. execution in over a decade and the first since the Supreme Court reinstated the death penalty in 1976.
Gilmore wanted to be executed and chose the firing squad instead of me.
I simply accepted a sentence that was given to me. I've accepted sentences all my life.
His execution sparked renewed debate over the death penalty. Some hailed Gilmore as a hero for accepting his punishment, while others condemned him for his crimes and the attention he received. The case revolved around Henry Dinkins. On July 10, 2020, in Davenport, Iowa, a girl named Breja Terrell went missing. In March 2021, fishermen found her lifeless body in a rural area north of Davenport. Following a thorough investigation, law enforcement concluded that Henry Dinkins was responsible for this tragic act and decided to press charges against him. The jury was tasked with the difficult responsibility of determining Henry's fate. After hearing all the facts, the jury finally reached a verdict.
The only truthful statement the defendant made during his interview with the police was that he went to the quick shop. The court finds none of the statements that the defendant made during the interview to be truthful in any respect. The court finds beyond a reasonable doubt the defendant was the last person seen with Breja. He had taken custody of her, had no authority to do so, and removed her from the apartment from which he had authority to care for her, with the specific intent to inflict a serious injury upon her, knowing that he did not have the consent or authority of Breja or her mother to do so. And as a result of that removal, Breja suffered, which is clearly a serious injury. The court finds beyond a reasonable doubt that Breja was shot by the defendant and that she died as a result of being shot. And the defendant did this act with malice aforethought, and the defendant acted willfully, deliberately, and premeditatedly with all the specific intent to kill Breja. All this occurred on or about the 10th day of July, 2020, and the criminal activity began in Scott County, Iowa, and the defendant's criminal activity continued as he traveled into Clinton County, Iowa. The court finds beyond a reasonable doubt that the remains located at the pond at the intersection of 2018 18th Street and 270th Avenue are those of Breja as a result of the testimony of the forensic anthropologist, Dr. Heather Garvin, and the medical examiner, Dr. Kelly Cruz. Matthew Dean and David Baker were both inmates at the Clinton County Jail while the defendant was being held pending trial in this matter. Both of them credibly testified during the airing of a news story concerning the disappearance of Breja. The defendant made the statement, "They are never going to find her." Both of these witnesses are credible, specifically Matthew Dean, who was no longer being held on any criminal charges, and David Baker testified he was not receiving special treatment in regards to any pending criminal charges in exchange for his testimony. Therefore, neither of these individuals had anything to gain from their testimony. Specifically, David Baker testified when he heard the defendant make the statement, he took the statement to mean the defendant knew where Breja was located. The court found every witness who testified on behalf of the state to be credible in their testimony. As noted, the only testimony the court did not find credible was that of DL, as to him being present and seeing the defendant Breja. The court's credibility findings are appropriate as statements were consistent between all the witnesses and were corroborated by the investigative efforts of the Davenport Police Department and the FBI and all other agencies. Again, it should be noted all of these investigative efforts would not have been fruitful had it not been for the information provided by DL. DL was instrumental in solving the murder and kidnapping of his sister Breja. The court specifically finds the defendant was not savvy in any manner. The defendant did not account for the statements and testimony of DL and that of Jared Brink. The evidence provided by these two witnesses clearly, and all the other witnesses, undermined every effort which the defendant may have taken to be savvy or calculated in his actions to avoid being charged and prosecuted for the kidnapping and murder of Breja. Ruling and verdict. Count 1, first degree. The court finds the state has met its burden of proof in this case. The court finds beyond a reasonable doubt the defendant committed murder in the first degree. The court finds beyond a reasonable doubt the defendant acted with malice aforethought and willfully and premeditatedly and with the specific intent to kill Breja Terrell her on July 10th of 2020. And as a result of being Breja Terrell, thus the defendant is guilty of the crimes of murder in the first degree. Accordingly, the court, based on the testimony of the witnesses and review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of murder in the first degree in violation of Iowa Code Section 707.2, paren 1, paren B. Count 2, kidnapping first degree. The court finds the state has met its burden of proof in this case. The court finds beyond a reasonable doubt the defendant committed kidnapping first degree. The court finds beyond a reasonable doubt the defendant removed Breasia Terrell on July 10th, 2020 from the apartment in which he was caring for her with the specific purpose of inflicting serious injury upon Breasia Terrell. The defendant knew he did not have the consent or authority of Breasia Terrell to do so, and as a result of that removal intentionally subjected Breasia Terrell to serious injury, that being. Accordingly, the court, based on the testimony of the witnesses and a review of the exhibits offered in this case, finds the defendant, Henry Earl Dinkins, guilty of the offense of kidnapping first degree in violation of Iowa Code Section 710.2. It is therefore ordered and adjudged and decreed that the defendant, Henry Earl Dinkins, is guilty of the offense of, under count 1, in the first degree in violation of Iowa Code Section 707.2, paren 1, paren B, and guilty under count 2, kidnapping first degree in violation of Iowa Code Section 710.2, as contained in the trial information filed by the state of Iowa. It is further ordered an informal pre-sentence investigation report shall be prepared by the 7th Judicial District Department of Correctional Services. The PSI shall be electronically filed by noon 3 days prior to the date of sentencing. It is further ordered sentencing in this matter is scheduled for October 11th at 1:30 in the afternoon. It is further ordered the defendant is being found guilty of forcible felony shall remain in the Scott County Jail pending sentencing without bond.
All suspects desire an opportunity to express their emotions to the jury. However, this chance is granted to some, but not to others.
What are you supposed to do when you're told you can't even speak in court, especially when you see and know something ain't right? Logistically, it's like having a gag order, which prevents you from addressing the court with any of the issues. What if your issues are with the judge, the prosecutor, or the attorney? You are not allowed to put anything on record at any time of these issues during the court proceedings, unless it's asked the question of the judge, the prosecutor, or your attorney. What happened to the rights of freedom of speech if a person addressed a matter to the court in the proper proceedings? Even if it's in the same spectrum as if your attorney or your prosecutor are addressing the courts or any issues. Your Honor, may I speak to the courts? There are so many various issues people might have at different times of the court proceedings. I believe these issues could be, I believe if these issues could be resolved between client and counsel, then there wouldn't be a problem. But that's not always the case. I'm only going to speak right now because this is my only opportunity to address the court during the closing of this trial, which is kind of too late for me. Even if you do ask your attorney to ask certain questions, sometimes things don't get done. I have a speech that I would like to address the courts with if the judge allowed me the opportunity to say the following. Let me address the facts about everything regarding my case. First, I want to know if I can quote case numbers or just saying the same, either or would be fine to me. Where is the justice in the judicial system, and how do you beat a system that is against you that's not playing fair? When I was in Clinton County Jail, I remember 2 detectives coming to charge me with this case. I remember the female detective saying, we're going to make you look like a monster when this is over. That statement was made during my initial report. Who is they? That's the $1 million question that will arise a little later further in this reading. I'm only going to speak facts. To be honest, I was already found guilty before this case and trial already began. I can see it as racial profiling behind my background. I'm saying this because how everything played out from the beginning all the way up to now. I contemplated over the moves that the state used to hinder my character to fit their benefits. First, they blast my name widespread coverage, negatively nonstop on the news, in the papers, and all over social media, and even on posters. This made me vulnerable towards animosity towards the public and guaranteed people to have a bad image of me in their thoughts. So if I chose a jury trial, this pretty much polluted their thoughts about the type of person they wanted to image me as. And all this went global for their support. Now I'm guaranteed not to get a fair jury selection for trial, and if I chose a bench trial, this it would be sealed with a guilty verdict. So where is the equal liberty and justice in the system when you're being railroaded? By the police, the detectives, and others working hand in hand. It really don't take no rocket scientist to see through this magnetic picture. Through these series of events, I know I've been railroaded, so either way, the state had the odds in their favor. The state produced 900 exhibits offered into evidence. I can honestly say I've only seen 35 exhibits before this trial, but I was given 665 exhibits during trial to have for my records. I never had the opportunity to look over 90% of any of this for preparation for trial, but this includes footages as well. So this is what the courts had to offer me. All this was new to me during trial, but I believe the 700 exhibits offered was the shortcut. I believe there are others that the state didn't provide, allowing the defendant preparation for trial by deception or by deception. So once again, where is the equal injustice in the judicial system when you're told you can't speak, especially when you see the state ain't playing fair? I do remember being transferred from Davenport to Clinton County Jail behind the bad publicized coverage. I remember a couple things taking place while I was being there. First, I asked for a change of venue behind the negative news. I also made the comment, man, they're never going to find her because it's been quite some time. As the time progressed, that even made it even slimmer. I also was going to represent myself because all the attorneys that the state was providing wasn't doing nothing in my case. So I just wasn't about to do nothing as well. So I at least was going to try to attempt pro se. When I seen the judge, he made the comment saying, I have no problem opposing this time on you. You need to reconsider your decision because you're facing some real serious charges. When I seen the look in the judge's eyes, I knew then I had to get a jury trial. But through the news press, through the news coverage and the news confirming this I know I had to get a jury trial, but through the news press coverage confirming this verdict with the high profile in this case. So my chances of winning even with a jury trial was slim, and if you don't have the right attorney, it's even slimmer. I was told by a birdie that if you have this case heard in any remote area where this is being televised, you would be found guilty, and this was by the state's own officials that uphold the laws. So once again, where's the equal liberty and justice for the system for all? This racism do run deep in the Iowa system for people of color, which I'm not only talking blacks. I know whites also have the same problem as well, but it's more common for men of color. But the profile racism that I'm dealing with is behind my background. And almost 75% of their news coverage, they mention my background or something in regards of that nature. If I didn't have that, I would have never got charged. When I was in Marshall County, before this trial began, here they go again, sliding negative news coverage of my background a week or so before my jury selection was about to begin. I said something to my attorney, which all he said was, there's nothing we can do about that. I made my mind up that if they're not going to play fair and I can't get a fair jury selection, I should just take my case back to Davenport. Once I was transferred to Cedar Rapids County Jail, before my trial, the day of my trial, here they was again mentioning my name on the news again. I really don't know a lot about the laws, but I know enough when I see a lot of my constitutional rights being violated from the beginning up to now. Through this racial profile, the state and others have shown ambiguous behaviors that sought constantly through these drawn lines. But what can you do when you're told you're not allowed to speak? I can only play with what's provided by the courts and the state's rules. Me and my family tried to contact my attorney on several different occasions, which I was told that he was working on the other client's case. To you, Judge Latham, you handpicked my attorney. I went through 3 different attorneys, but the handpicked one was my last option. I'm not going to bash my counsel because I know he personally did more than the Davenport public pretenders. But I know he overlooked some things in my case. I'm not quite understanding how I wasn't given 665 exhibits or seen any footages before this trial. He did make me believe he was going to raise these issues, but I never seen nothing come forward. I've asked several times, but was told you have nothing to worry about. I was being bamboozled by the blind side while nothing was being introduced or brought to the surface. I really don't know if this would have made a difference because the judge was just looking for any reason to get this verdict. I can truly say after hearing the judge's remark and while I was in Clinton and Cedar Rapids, the judge's demeanor spoke real clear to me of the courts, which made me realize that I never had a chance to win from the beginning. So once again, where is the justice in the judicial system when you see the judge in his own personal emotion, then you hear the judge say that everything made against you, he find credible, then tell you everything you said is a lie and untruthful, even when they know you know they lied. I do understand the power of the pen, especially when the power of authority is being abused behind watchful seers. I do wish situations were different, but the state has played dirty when they know they didn't have anything on me while I was their easiest target behind my background. I would have to say this is overwhelming, but I have to stay focused and grounded. I have more hurdles that I have to jump through, but I have to take things one step at a time. For those who believe this fight is over, guess what? Through my resilience, you will see me at the next checkpoint, God willing. My main focus is getting back home, but where is home after all this? Where is home? But right now, I have to stay focused on what's more important. I'm only able to play with what's provided by help from those who are watchful seers as well. I know the court has played unfair towards me. I played this scenario numerous times in my head trying to figure this out, but I keep coming up with the same answer. You never had a chance from the beginning. So I say this to you, Judge Layden. What if you wouldn't have never found me guilty and found me innocent? What would have been the outcome from their perspective? Everybody have to report to somebody, but God is God is the final ultimate judge. I do forgive those who made past judgments against me unknowingly. Never once have the courts asked me about anything of the clothing or the shoes or during any of these allegations. I honestly believe that these items are not important, but it was just giving the state more ammunition to point a finger negativity towards me. Just like me not opening Andrea's door with my key to allow the police to walk into her residence. I don't have them rights for that. I don't pay no bills at her apartment to allow anyone access to her place. I didn't give no approval for her place for that. I didn't give no approval for a place that's not my place of authority to do. On the footage, I told him I checked, and he said, let's check. And then lied and said I told Andrea, and then he lied and said I said it was okay for him to go into Andrea's house. But I will have to say the video do speak for itself. I will have to say there was one person's statement that was consistent from the initial report to deposition to trial, and that was Miss Gardner, Aisha's mom. I do recall her talking to Aisha before I left with the kids, or I would have never left with either kid. I'm still stumped about 900 exhibits plus, and I'm saying plus because I've only received 700 and the state knows that the ones that would have set me free, they used deception and sabotagement, but made a mistake by giving me 665 exhibits during trial to go through and to cipher through after trial. I know I was given 665 because I counted them, which I've already had 35 before this trial, and which gives me 700 in total, except for the ones I gave my attorney when the state moved them exhibits to move things into mobile to fit their exhibits.
When determining a suspect's sentence, a judge always considers whether the punishment fits the crime the suspect committed.
Mr. Dinkins, pursuant to this court's finding you guilty on September 15th of 2023 in the first degree in violation of Iowa Code Section 707.1, paren 1, paren A, and as provided by Sections 902.1, it is the judgment and sentence of this court that you be committed to the custody of the Iowa Department of Corrections for the rest of your natural life without the possibility of parole. Pursuant to this court's finding you guilty on September 15th, 2023 of kidnapping in the first degree in violation of Iowa Code Section 710.2 and as provided by Iowa Code Section 902.1, it is the judgment and sentence of this court that you be committed to the custody of the Iowa Department of Corrections for the rest of your natural life without the possibility of parole. DNA sampling will be required. Each of these counts will be served consecutive to one another for the reasons stated earlier. The Iowa Medical and Classification Center is designated as a reception center to which you shall be delivered by the sheriff. Pursuant to Iowa Code Section 910.3B1 in paren 1, you are ordered to pay to the heirs of Reasia Terrell, and as noted by the county attorney to Aisha Langford, $150,000. Mr. Freeze, do you wish to address Category B expenses at this time?
Your Honor, I believe that given Mr. Dinkins' status presently and going forward, he'll certainly be indigent, qualified for a waiver of Category B expenses.
Ms. Cunningham, do you wish to address the court on this matter?
No, Your Honor, and the state would not resist the court entering that finding.
Based on that, the court will find that Mr. Dinkins is indigent and does not have the reasonable ability to pay Category B expenses. Now that you have been sentenced, it is my duty to advise you of your right to appeal. Under Iowa law, you have the right to appeal your conviction and sentence to the Iowa Supreme Court. In order to do so, you must file a written notice of appeal with the clerk of this court within 30 days from today's date. Failure to file such notice of appeal in that fashion will be deemed a waiver of your right to appeal. In other words, you will lose it. If you think you want to appeal but don't think you can afford an attorney or transcript of these proceedings for that purpose, you have a right to make application with this court for court-appointed counsel and a transcript of these proceedings, all at the expense of the state of Iowa. Just be aware all of this must be done within the 30-day time limit that I have just outlined. I'm sure if you have any questions concerning this, Mr. Freeze or Mr. Waters would be happy to address this with you. I'll acknowledge receipt of any pre-sentence investigation reports that have been printed for the purpose of today's sentencing. No appeal bond will be issued in this case. Minimus will issue immediately. Anything further in this matter?
Your Honor, I do want to make a record relative to some comments of Mr. Dinkins. Mr. Dinkins spoke to the issue of the state having provided all of these exhibits during the trial that he had not received. The state did comply with all discovery requests that were made. I would note that there were a significant amount of photographs. There were significant...
On November 9th, 2021, in North Bottom Road, Adams County, Bradley assaulted 77-year-old Tina, first in her car and then at her home. Police arrested Bradley after Tina's husband reported the crime. Tragically, Tina passed away on December 12th. It's difficult to hear a criminal talk about justice, logic, and principles, but the courtroom ensures everyone can speak up.
I also intend to prove you improper procedure, coincidences. Throughout this trial, you'll see some of the most major coincidences you have ever seen in your lives. And they are established, and I'm sure some of the witnesses will attest to them. There are major coincidences in this case. As stated, I talked about logical. I intend to show you that these things do not follow the definition of logic. I will show you what coercion, manipulation, and deceit is. I will show certain persons think it is absolutely funny to be vindictive, to lie, to place forth claims, and that would be from the horse's mouth. I will prove to you reason for false testimony from some who may or may not testify throughout this adventure. I'll show you how other law enforcement think these events that are alleged to have happened are quite odd themselves, stating such in an indirect way. That is law enforcement, and I intend to prove that to you. I will show any of the claims and things placed forth by all here today, witnesses and the claimant herself, just do not add up or coincide with each other. The prosecution intends to prove to those of you that a 77-year-old woman has been brutally beat, battered, assaulted is the proper pronunciation or the proper usage, term usage in trials. They intend to prove to you that a 77-year-old woman was home invaded, kidnapped, hijacked, stairs at 77 years old. Stairs. Some of you are young. If you were thrown downstairs, what would that damage do to you? Stairs in a violent manner. The prosecution intends to prove to you that a 77-year-old woman was downstairs in a violent manner. All these claims are violent. They're sick. They're demented. All of these being brutal, violent, heinous. Those are the titles of alleged claims the judge has placed forth, as Ms. Keck has also stated, what I've just relayed to you, and more. Some of these descriptions you will hear throughout this trial. I aim to present to you, those of you here today, and I aim to present to those of you from the mouth who spoke them, these claims, and that they are not true. What's better than the person who spoke them? Attorney here, Mr. Jones and Ms. Keck, I believe they both have great intentions. I'm sure they do. However, they're here to attest to something they do not know themselves. They do not have full and 100% proof of. They're just doing their jobs. I don't expect you to hold it against them. I only expect you to be fair. I spoke of, at the beginning, this being very hard for me. Obviously it is. I'm the defendant here today. It's my life in jeopardy. It's my life on the line. Not only is it hard for me, I spoke of it being hard for, well, everybody here. I'm sure those of you in the jury today did not want to hear the sickening claims or have to go through this. All we can do is take what we have and place weight on it from our own views. Mainly you people here today, you jurors. Today you will be presented what some call evidence. Some of these presentations are very odd and would lead you to say, guilty, he's guilty. These are what I spoke of when I said I'd show you coincidences. Those coincidences are by far some of the biggest coincidences one will ever see in a lifetime, most never seeing such. Never having the chance to. Why? Because there are coincidences that are extremely rare. There are things that just don't happen. A believer of coincidences is what I intend to make you throughout this trial. Ladies and gentlemen, as I said, devious crimes, they are what I myself would call the worst, the very worst. I think they're worse than me. That's my point of view. That's if they were true also. I do not mean to offend anyone here today. However, they simply are not true. My little brother used to run to Mother and say, "Mom, BB hit me." BB was my sister. He used to say, "BB hit me." Mom would say, "Well, my lovely young man, where are the marks to prove such?" Well, Mom, show me the marks. He could not show any marks. Mother would say, "I can't tell where the marks are." True story. Come to find out, my brother only had the remote taken from him. Scooby-Doo was his favorite. He would watch it end on end for hours. During them times when my brother would make them claims, we would all come to find out in the end that he had just simply walked away from the TV. Sis picked up the remote and he wanted the TV back. The tales he was telling, you will see that today, here, and throughout this trial, there are major tales told. Tales that are tall, simply very tall tales. Then, in reference to my brother, the lack of marks gave my mother reasonable doubt. Today, I intend to prove an extreme amount of reasonable doubt. Throughout this trial, I will prove extreme amount of reasonable doubt. Reasonable doubt, they say, is any idea or condition that interferes with a person.
Grounds.
All right. The jury is left to find reasonable doubt on their own.
Sustained.
Jury, throughout this week, there will be all kinds of words placed forth, strong words, educated words, words some of us may not understand. There will be displays. There will be what many call evidence, and there will be testimonies. I will show you, and if you may, prove to you how things are not as they say, not as they seem, how most just are not possible, also known as impossible. As I stated earlier, I intend to be logical. I will do just that. I humbly ask that you bear with me throughout this process, bear with all of us, those of the court, those of the prosecution, and everybody. Recesses, intermissions, just please bear with us and be honest, as I'm sure you all can be, and be fair. Thank you.
In certain situations, the criminal may try to defend themselves. However, can any defense truly justify the crime?
Yes, I do, most definitely, Your Honor. Ladies and gentlemen of the jury, today we're here on some sick, heinous matters. Matters that, if I were that person, I wouldn't care if I was a prosecutor or not. I wouldn't sit here and call the defendant a man. I'd call him a piece of excuse my terminology, Your Honor, but I'd call him a piece of because that's what he would have been. Mr. Jones has put on a great presentation today. Very great. Just like Miss Keck did on Monday last week. She put on a great presentation. Very abnormal and not her normal voice. Not her normal voice at all. She come forward with a presentation that seems so unnatural just to try to persuade you people. Just to try to persuade you. You see the woman right here on the screen? That's from a video. Does it appear if she's hurt, battered, beat? Persuasion. You can persuade anybody to do anything with words. You can persuade them with actions. You can persuade them with evidence. Sometimes evidence isn't evidence. In the beginning and during opening statement, I spoke on a limited amount of issues, things if you may. One of them was persuasion. Mr. Jones, he's good. He's got words. Being persuaded. People often in life persuade others, as I said, with words, actions, evidence. They also persuade people with lies, deceit, vindictiveness, falsities. They try to place theories together and put stories together and embed them in the minds of jurors such as yourself or people out here in the community. You see Mr. Jones here repeatedly stated, beat, battered, hijacked, to try to embed that in your mind, violating this family here. What family wants to remember that if it's really true? What family wants to have that embedded in their minds? I spoke on being logical in the opening argument. I spoke on how being logical is logical. Correct reasoning, cause and effect. I promise not to attempt to persuade you, to manipulate you. I'm still not going to. But one thing I'm going to tell you before I go any further is I'm not a creep. A person who does them things are creeps. They're sick. What I think they deserve is one of them pistols right there on the man's hips to be taken and having their heads blown off. And that's just being point blank honest. I've never been a creep. Never will I be a creep. Persuasion. The state has presented a case to you formed out of mostly false accusations. Accusations not produced by them. Accusations produced by a declarant. You didn't get to hear that. You heard it from the grapevine. Mr. Jones heard it from someone who heard it from another. And them others heard it from someone. I want to speak to you on some things that we've heard and saw in the last few days. As I've already stated, you heard Miss Keck. She put a heck of a presentation together. Husband Schmidt, you heard from a man who is led to believe from his wife that certain things happened to that certain things happened to her. You heard how their home was robbed, their car was stolen, his wife was brutally beat downstairs. You heard Mr. Schmidt say he left after 5 p.m. After 5 p.m. In the state's direct examination, you heard him state after 5 p.m., approximately 5 to 10 minutes. Upon cross-examination and recalling Mr. Schmidt, it changed to a little bit before 5, right around 5. It takes approximately 5 to 8 minutes to get to farm and home. 30, 40 minutes there. It puts you at 5:50, 5:55, 15, 20 minutes home. All the way out to North Bottom Road, 4300 Bottom Road. Put you after the time of 911 call. And that's a fact. You didn't see that though. You heard Mr. Schmidt state that he was in his garage and he made this call by himself. By himself. At the opening of his garage. Is exactly what you heard. You heard that from Mr. Schmidt. But did you not hear the facts though? There was another person on that phone call. It wasn't by himself. It wasn't by himself at all.
The jury plays a crucial role in the success of the judicial process. They reach their verdict after careful deliberation. However, the judge always has the ultimate responsibility for determining the sentence.
We, the jury, find the defendant, Bradley Yawn, guilty of home invasion with a dangerous. We, the jury, find the defendant, Bradley Yawn, guilty of home invasion, criminal assault. We, the jury, find the defendant, Bradley Yawn, guilty of aggravated kidnapping. We, the jury, find the defendant, Bradley Yawn, guilty of aggravated vehicular hijacking. We, the jury, find the defendant, Bradley Yawn, guilty of aggravated criminal assault. We, the jury, find the defendant, Bradley Yawn, guilty of residential burglary.
Thank you. Mr. Yon, do you wish to have the jury polled?
Yes, please.
Clerk, would you please poll the jurors?
Juror number 33, were these then and are these now your verdicts?
Yes.
Juror number 15, were these then and are these now your verdicts?
Yes.
Juror number 50, were these then and are these now your verdicts?
Yes, ma'am.
Juror number 84, were these then and are these now your verdicts?
Yes.
Juror number 78, were these then and are these now your verdicts?
Yes.
Juror number 46, were these then and are these now your verdicts?
Yes.
Juror number 87, were these then and are these now your verdicts?
Yes.
Juror number 58, were these then and are these now your verdicts?
Yes.
Juror number 72, were these then and are these now your verdicts?
Yes.
Juror number 2, were these then and are these now your verdicts?
Yes.
Juror number 43, were these then and are these now your verdicts?
Yes.
Juror number 80, were these then and are these now your verdicts?
Yes. Thank you. To the members of the jury, the court wishes to express appreciation for your services as jurors in this case. Other than military service, jury service is one of the highest duties of American citizenship. When this country won its independence, trial by jury became the keystone of our system of justice, the connecting link between the courts and the people. It is one of the blessings of a free society. There is no more sacred public trust than to be chosen as a juror to try a case, to sit in judgment on the acts and motives of one's fellow man. The law, which is the court's duty to declare, is found with comparative ease, but the facts of the cases of which you as jurors are the exclusive judges are nowhere written, are usually in dispute, and are found only after the jurors have determined the truth from evidence before them. No case is easily decided and considering that some 95% of all civil and criminal cases are settled before they reach a jury. Juries such as yours are called upon to serve on only those that were impossible to otherwise resolve. I make these remarks upon discharging you from further service in this case, not only in appreciation of your service here, but also to give due recognition to the exalted character of jury service in every case. You have been taken from your daily routines for this task, and I thank you for your patience and thoughtfulness throughout this process. You were told throughout your jury service that you were not to discuss the case with anyone. That no longer applies, but you have the right not to discuss your jury service or the case with anyone if you so choose, or to choose to discuss the case if that is your preference. I will make myself available in a few minutes in the jury room if you have any questions about the process or comments about the experience that you would like to share. However, you are not in any way obligated to stay and may leave at this time. I may also send out a survey to ask for information about your experience. I would appreciate it if you would share your thoughts, but again, you can do so at your leisure and if you so desire. You are hereby discharged as jurors, and I thank you again for your service. Thank you.
No matter how hard the criminal tries to prove their innocence, the judge ultimately reviews all the evidence and delivers fair sentences.
The defendant has an extensive history of prior delinquency and criminal activity, including not less than 12 misdemeanors, but more importantly, sentences to the various departments of corrections in Illinois and Missouri, including 3 years, 3 years, 3 years, 5 years, 4 years, 3 years, 3 years, and 7 years. None of which curtailed Mr. Yon from committing these offenses. The court finds that a sentence is necessary to deter others from committing the same crimes. Specifically finds the victim to have been 65 or 60 years or older, being 76, 77 years of age. I also note that according to the PSI, Mr. Yon was on a pretrial release for a felony in St. Charles County, Missouri, 2111-CR-03413, an unlawful possession of firearm by a dangerous felon, a Class C felony in Missouri. Also, Marion County, Missouri, 21 MR-CR-00188 for a charged second-degree burglary, which would be a Class 4 felony in Missouri. In reviewing the factors in mitigation, I am in agreement with the state's position. I find none that apply to Mr. Yon. And again, the court is to consider the character of the offender. Mr. Yon, in my practice of law and in all my years, you are the most reprehensible person I've had in court before me, as public defender, as state's attorney, and now as judge. You take no responsibility for crimes that you clearly committed and were proven beyond a reasonable doubt. I believe you're narcissistic and unable to appreciate that, because to admit that would be admitting a fault, and in your mind, you are perfect. Well, sir, you're going to be perfect for 130 years in prison, because I'm adopting the state's recommendation. On count 1, home invasion for using a dangerous weapon during such, the maximum 30 years is imposed. I'm also finding that that crime resulted in great bodily harm to the victim, meaning you'll serve it at 85%, not 50%. That'll be followed by 18 months mandatory supervised release if you're ever released. Count 3, aggravated kidnapping, Class X felony. I'm imposing the maximum 30 years. Department of Corrections. That likewise will be at 85% for the same reason as previously stated, inflicting severe bodily injury. That will be consecutive to the sentence in count 1. Count 4, aggravated vehicular hijacking. Class X felony, 6 to 30 years. I'm imposing a 30-year sentence maximum, followed by 18 months mandatory supervised release, specifically finding that that should be served at 85%, again, because your actions resulted in great bodily harm to the victim.
Christine Lohman even said she wasn't hijacked.
Sir,
herself.
I would not speak.
In the video.
So that will be consecutive to counts 1 and 3. Count 5, maximum on the Class X aggravated criminal assault, range 16 to 40 years. I'm imposing the 40-year sentence. That will be followed by mandatory supervised release of 3 years to life, and that by statute will be mandatorily consecutive to the sentences imposed in counts 1, 3, and 4. Those should total the 130 years being imposed.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.